Hello. Hi, hi, hi.
Yeah, finally.
Yes. Yeah, welcome.
Thank you.
Let me just share the link quickly so that people can join in.
Okay. Yeah, Judy, the link, the link
Yes.
I've shared on my status.
Okay. The recent one that I just sent.
That's the if you say recent, which one?
I just sent you one because we are live. We are live now. So the one that I used to register, it's not opening. So I'm just doing this straight. Oh, okay. Okay. So we can start in the next minute. Let's wait a little for a few people to join. Okay, Aaron, I'll send you the link. All right. So, Prince, if you are ready, we are also ready. Good evening or afternoon to everyone. My name is Judy. Thank you for joining us today on this webinar. This webinar is meant to enlighten any individual that is interested in or maybe has started these steps or would one day think of buying a land or a property in Ghana. This webinar is to help you and guide you through what you should know as a beginner, as a pro, or anyone just interested in the real estate market in Ghana. So, my name is Judy. I'm a property consultant in Accra, Ghana. And I have with me here our guest speaker, Prince Benson Mankotam, who is a lawyer, a legal practitioner, and he is going to be our speaker for today. So without wasting much time, Prince, you can take over.
Okay. Hello, everybody.
Hello,
Good
Prince.
afternoon. Can you hear me now?
I can hear you.
Great. Good afternoon, everybody online, and good afternoon to all those who are still joining. Um, Today would be very exciting because we are discussing a topic that is of interest to a lot of people, which a lot of people to take for granted, and as such, raises a lot of legal issues in court. I am aware that um, land issues, land litigation forms the bulk of what we have. And it is very important that we all get to know um, what it takes or what should be done as far as the acquisition of land is concerned. And so today, my task is very simple but complex. Um, to let you know some of the matters that relate to land and its acquisition. And so I'm going to talk about 6 things, if time will permit us.
Okay.
One, we will talk about what an interest in land is. We also talk about what types of land we have. People don't know that there are restrictions on the acquisition of land in Ghana. And so we will also delve into that. We'll look at what matrimonial property and what a corporate property is. I mean, still in the context of land. And we'll continue with the management and the alienation of land. And then we can end with the proper procedures that you're supposed to follow when you want to acquire land. I am sure that everybody is following. So let me move
Yes.
straight into action.
Okay.
So, what is an interest in land? Many a times, people hear interest and it means, oh, some form of um, taste or some form of um, an eye for something that you would want to have as a property. But when you talk about interest, interest is different.
Okay.
Interest in that, and you before you get to know what an interest in land is, you're supposed to know what land actually means as far as the law is concerned. So, in law, when we talk about land, it is not only the surface of the earth that you occupy. That's the most interesting aspect. Land is that surface soil, whatever is on that land, whether it is a river, a stream, lagoon, um, let me say, crops, plants, vegetation, all those things on it, buildings, yes. And what is also to some extent beneath it. And sometimes we even say some level, as far as what is above you, that is the sky, that is land. There's a particular level that you can claim as far as the airspace is concerned, and that forms part of the land. And so when you check the new Land Act that was passed in 2020, you see that it is very clear what land is. The law says that it consists of the surface of the soil, trees, plants that are on it, buildings on it, and any movable property over it. So that is what we call land in Ghana. So you have to bear that in mind. But it does not necessarily mean that if you go and buy someone's cocoa farm for 10 years, you've bought the land in addition. No, it is because the law construed that to be a license over the cocoa or the cocoa trees that are on that land. And so you did not buy the land, you bought the cocoa or the cocoa trees on that land. And so we have to get that very clear. So what is an interest in land? The same Land Act, the same Land Act also defines what an interest is. And it says that or interest over the land, which is registrable. So it means that you can have a right over a land that is not registrable. There are some rights we have that are not registrable, which maybe subsequently we will delve into those
Okay.
things. But for the
Mm.
purposes of today's webinar, we are looking at the surface. And so in the same act, the act mentions 6 different interests in land which are registrable. When we say it is registrable, it means that it has the potential of being registered, or you can go to Lands Commission and get it documented. That is the registration. So if it is not registrable as far as the law is concerned, then you act. And so we have 6.
Okay.
The first one is the allodial title. I'm sure some people have heard this before. Allodial title. The second is called customary law freehold. The third one is called usufructuary interest. Some people call it usufruct. The fourth one is called common law freehold. The fifth one, which is very common in Ghana, is what we call the leasehold interest. And the last one normally exists in the villages. It is called customary tenancy. So I'm going to take the pains to go through them one after the other. Not so much into detail, but those little things, basics that you are supposed to have to help you acquire land in a proper way. So let's look at the allodial title. The allodial title, as far as the law is concerned, is the highest form of interest you can get in Ghana. We always say it is the ultimate. It is because it is potentially perpetual. You can have it till thy kingdom come, and you don't answer to anyone. Maybe you answer to God one day when you appear before him, but as far as human beings are concerned, um you are not answerable to anyone when you have the allodial title. And the allodial title is what mostly the state, schools, skins, and families they have. When I talk about skin, I'm talking about kinship in the northern part of Ghana. And then when I talk about stool, I'm talking about the southern part of Ghana, the symbol of authority of the chiefs. So if you hear Otikokoso, it means the stool that the chief sits on is gold. Yes, but when you go to the north, they sit on a skin. They sit on skin, and so we call them skin. And in the southern part, we call them stools. And then we have families and clans. Clan like Oyoko, Diana, that kind of thing. Huh. Those people, most of them, I'm not saying that every stool land is an allodial title, but I'm saying that allodial title is mostly held by stools, skins, the state, families, and then clans. When it comes to the acquisition of the allodial title, there are so many ways of acquiring it. One of the ways that the state acquires the allodial title is through what we call compulsory acquisition, which is provided for in Article 20 of our Constitution, 1992 Constitution. There's a procedure that is laid down for the government to compulsorily acquire land from a stool, a family, or a skin. And so when we say you are compulsorily acquiring it, it means that the state is taking it by force, whether you agree or not, for the interest of the state. Yes, most of the stools and skins, they acquire the allodial title through what we call conquest. So in the olden days, there were a lot of wars that were fought. So I conquer you, I take your land. And so it will mean that he has taken whatever you had in
through the
whole.
war.
Exactly. So that is the conquest. It was also acquired through what we call pioneer discovery and settlement. So in the olden days, people were migrating here and there. Not only nomads, but most of the tribes, most of the the families were migrating. When you ask the Gans, they will tell you where they migrated from. When you ask the Asantis, they will tell you. When you ask the Fantis, they will tell you. Some of them are stories we cannot verify, but it suggests that people have moved from places to where they are now. And so whilst they were moving, they were occupying certain portions of Ghana, which were ordinarily at that time were unoccupied. And so they reduce such portions of land into their occupation, they settle there, and it becomes theirs. So you start to think why there's a portion that when you go, you see that all of them speak the same language. It means that and settled. And that's how they got their allodial title. It can also be acquired through gift. Some ethnic groups migrated somewhere, even though they met other ethnic groups. Because of good deeds, some people gifted them land just to show appreciation, and then they acquired the allodial title. Now let's look at the second one, customary law freehold. I want everybody to pay attention, because this particular type of interest cannot be acquired anymore in Ghana.
Okay.
It does not mean that if you acquired it before it was banned in Ghana, it means that you lose it. But upon the promulgation of the 1992 Constitution, customary law freehold is no more someone will say acquirable. You can't acquire it in Ghana. The reason is that when we talk about customary law freehold, it means an interest in land that a person acquires through outright sale from an allodial holder. So you see that most people go to these chiefs and let me say, I'm trying to get a name for the chiefs in the north. Well, people will go to the Yana, people will go to the Nairi and all. Yes. And they say that they want to buy the land. So when you come to the Asante side, they say, oh, me person me to asase crack. Something like that. You can't buy that asase crack because land that belongs to a stew or a skin in Ghana is deemed to be a property for the generation that is dead, the generation that we have now, and the unborn generation. Exactly. So 3 different generations is for them. So the mindset behind it is that say you get it.
Yeah.
If it was sellable, would you have come to meet it? They would have sold everything. So it means that if we allow chiefs and we don't have kings here, chiefs and occupants of stools and family heirs and all those, yes, to sell those things outright, those generations unborn will not come to meet any land that they will also enjoy as family members, as subjects of the stool, or as citizens of Ghana, something like that. So that is why we have proscribed the acquisition of customary law freehold in stool and skin lands. Then we have the third one, which is also common, but people don't really pay attention to, what we call the usufructuary interest. It's a very long name. So normally, if you don't want to bite your tongue, you just say usufruct, so that you don't go and say usufructuary and bite your tongue. Yes, that is also a very big interest in land. Normally, we say that it is potentially perpetual, which means if you acquire it, you can transfer it to your sons and daughters. They will transfer it to their sons and daughters. They also transfer it to their sons and daughters because you acquire it for a long time, like potentially perpetual. Nobody is going to question you that you've done so and so, so drop it, unless maybe there are some customary practices that you have refused to perform, or some rules that you have flouted, which we will get to. Now, this usufruct normally, I'm choosing my words carefully, normally is acquired by one, subjects of a stool; two, members of a family or members of a clan; and then three, maybe people who are not indigents of the family that holds the allodial title, or the stools and skins that hold the allodial title. So I'm taking them one after the other. Where you are a member of a family, or you are a subject of a stool, there is what we call an inherent right to enjoy the benefits that come with land that belongs to that family you belong to, or that stool you are a subject of. That's the reason we don't want, the occupants or the family has to sell the lands, so that those who are members or those who are subjects will also enjoy. And so you have an inherent right to enjoy. And so to exercise that inherent right, all that you have to do is that you identify a portion of that land that belongs to your family, which has not been reduced into occupation by any other member. We call it unappropriated portion of the land. It means that nobody has occupied it or nobody has taken it. You identify that. You tell the head, whether the occupant of the stool or the family head, you just enter upon it and you farm, or you reduce it into your occupation. Then that portion you have reduced into your occupation becomes yours by virtue of the fact that you are a subject of the stool that owns that land, or you are a member of the family that owns that land. That is how, if you are a member or you are a subject of a stool, you reduce, you acquire the usufructuary interest.
So
Now,
in this
there are
scenario, that portion of land is not sold to you, is it?
your line was breaking a little bit, so I could not hear you.
Okay, I'm saying so in this scenario, that portion of land, was it sold to you, or you can only use it for a period of time and then it reverts back
No,
to
no,
the
it's not
family?
sold, and two, not for a period of time. It's not sold and it's not for a period of time. That is why I said that it is potentially perpetual. It is
Mm,
land that nobody occupied, nobody had reduced into his. And so you went there to take it as you being a member of the family of it. So it means that from there you can transfer it to your sons and daughters. They will transfer, nobody can sack them.
okay.
That is why it is said to be potentially perpetual. Yes. So yes, that is for members or subjects of the zoo. So someone will be
So
asking,
yes,
what?
that is for.
Sorry, I paused because I was getting feedback.
Oh,
Someone would also ask, what if I am not a member of the family or a subject of the zoo? If you see an unoccupied land and you are able to settle on it with the consent of whoever has the allodial title, whether it is a Sioux, a family, or a clan, and you settle there for at least 50 years, it means that you have acquired the usufructuary interest, even though you are a non-indigent. That is what the law says. So what you are supposed to do is that, one, get consent from the allodial title holder, settle on that particular portion of land. I mean, on agreed terms, of course, and prove that you've been there for at least 50 years. It means that that land has become yours, and the interest you've acquired is called a usufruct. I am sure. I just hope that I'm making sense, and I'm not using too many legal jargons. I'm
mm,
just being careful. Yes.
mm,
Now, the fourth one is called common law freehold. Common law freehold is quite difficult getting them in Ghana. The reason is that even though they exist in our books, in reality, they are not really being given or I mean being acquired. So common law freehold, some of them are what we call fee simple. They are just like customary law freehold and usufruct and all those things. And so the names still exist, but they are not really being acquired or being given in Ghana. So those are transactions that exist or existed or are being done under the common law. So assuming that someone acquired a fee simple before our constitution or before this particular act, which was passed in 2020, it does not mean that because it was um, transacted under common law, it is not acceptable. The law says that you can register it. So anyone who has a document in which they have written that the interest he's acquiring is called fee simple. It means that you have to look at the date it was given, and if it predates this law, it means that it's okay. You have a registrable title. However, those ones cannot be given where the land is a stool land or a skin land, because of the reasons I stated earlier, that those lands are for the generation, the dead, I mean, generation that is dead, the generation now, and the unborn generation. So you can't just sell it like that. Yes. And the fifth one, which we are all very interested in and have seen a lot around, is the leasehold interest. So the leasehold interest is an interest in land that has a specific duration. So you see that you can ascertain, or you can be very certain that this is the number of years I have this land for. So in Ghana, the maximum number of years you can have a lease for at one time is 99 years. That is at one time. And then maybe you say that another contract says that after the 99 years, you want to have it up for another 99 years. But in one document, you can't say that you are going for a lease for 150 years, 100 years. No, we don't do that. So that is a leasehold interest. You should understand that lease can be lease where they've given you 99 years. But someone who have a lease of 99 years, he enjoys the land for about, let's say, 20 years and says that I am selling. So if he's selling the land to you, means that he's only selling to you what he has. So you have to negate or deduct the 20 years he has spent from the 99 years he got, which means it's left with 79. If my mathematics teacher will be proud of me, I'm sure that I am right. He has 79 years, and the 79 years will be what you are acquiring. So if he is giving you all the 79 years, it is no more a lease. It is called an assignment. It means that he is assigning all that he has to you. He's giving all of them, all of it to you. However, if he has 79 years left and he says that, well, maybe my child is likely to reach 90 years before he dies, so I'm only I only need money, so I'm only going to give 37 years out of the 39 years out of the 79. That is called a sublease. So the lease he got, he is carving some for you. That's a sublease. So that's it for a lease hold interest. Now, the last one, which is the customary tenancy, that is what is known in the Akan setting as Abunu Abusa. So you go to someone who has land and you ask the person for a farmland that you don't have money to pay. And so when the produce comes, or the produce are ready for harvest, you harvest and you divide into two. He will take one, you have one, which means the half you are giving to the owner is his rent. That is what we refer to as a customary tenancy. People will say that, well, I want to keep my produce, but I'll pay you rent, yearly rent. So he will give it to you for 5 years. Every year you go and give him money. Every year you go and give him money. That kind of thing. That is a customary tenancy. So that's it for interest in land.
Okay,
Now,
I have a question. With regards to the lease,
yeah.
if somebody has, let's like with the example that you gave, if I have
Mm-hmm.
about 79 years left,
Yeah.
is there a minimum number of years by law that you must sublease for? Or you can decide that, okay, I'll just sublease for 10 years. What happens after the 10 years, or what happens after the 50 years that you are subleasing for?
So there is what we call reversion. It means that after the years you give to the person, the land has to come back to you, as if you've sent your child to school and you've vacated. He has to come back home. So if you had 77 or 79 years left, and you say that you don't want to give out all the 79 years, but you are giving out 50 years to whoever wants the land, it means that after the 50 years expires, the land will come back to you. So the land will become the property of the person who gave the land to the one who acquired the 50 years. So sometimes those documents you see sub lessee, sub lessor, that kind of thing.
Yeah.
So immediately you see sub lessor, it means that that person has a lease, and whatever he is giving you is not the full number of years he has. He's giving you some. And we don't specifically have number of years that you can give a sublease for barest minimum, because
Okay.
it is like you are carving something out for someone. However, normally we see the shorter terms to be tenancies, like a shorter term, 5 years, 3 years, 4 years, 7 years. Those ones are normally seen as tenancy agreements. But when it gets to 10, 15, 20, it means that it is a sublease. That is one of the ways you would use to identify or to differentiate between the two. Yes.
Okay. Okay. So one last question before we
Yes.
move on. Someone is asking, after the 99 years, you who bought it, the lease, the lessee, after the 99 years, what happens? The chief, do they come back for it? Do you have to go and pay something if you want to renew? What happens? They come and then they come and collect the land, or what?
That's a very important question. People take lease and they look at 99 years, they look at their age and say that, oh, by the time 99 will elapse, I will be dead. They don't really think about the fact that they may give it to their sons who will have sons or and daughters. So there are some people who had 99 years, a 99-year lease in 1920. If you add 99 to 1920 now, you will get, I think, 2019 or something.
Yeah.
It means that that land is lost. The reason is that you asked for it for a specific term. When you finish enjoying it, it goes back to the owner. If this is a bottle, if I say that I want to drink up to this point, immediately it gets to this point, it means that whatever I paid, I'm done.
Yeah, done.
So whatever is left, it's not mine. I have to give it to whoever I took it from. And so we always advise people that in that lease agreement, put in a clause that lessor will give you automatic renewal, subject to a review of the rent. So the reason is that, of course, some years ago we used to buy fuel at 4 cedis. Now, per liter. Now it's 12 cedis something something. Even yesterday it was 12.95. Today it is 12.6. It means that the currency or the value of money is not that stable. So you don't expect that you buy a plot of land 50,000 now, and 50 years from now you still buy it at 50,000. So it means that they will review it. And so it is possible that they will review, but it is important to state in that lease agreement that you are entitled to automatic renewal or first right of refusal, which means that after the 99 years, you are the first person they should ask if you want to buy it. Yes. So that's what happens
Okay.
after the term you get.
Okay. So I think Zako is asking, I want us to proceed. So we'll take this as the last question on this section. He's saying that, so let's say now we've gotten to the end of it. And for example, you didn't include it in the agreement. You didn't include a clause that they should give you the first right of refusal, or there should be an automatic renewal. Okay, whatever structure you have put up on the land, will the original owners of the land come and break it down?
Mhm.
Or what is the process like? Let's just
Mm.
say if you didn't include that clause inside the agreement.
You
And
see,
even if you did, sorry, and even if you did, can you still enjoy the land automatically until whatever rent is reviewed or whatever agreement is made?
yes. So let me start it from the last bit of your question. You have 99 years. I'm sure whoever bought it will not be alive at the time. Considering that, unless maybe the person bought it at the age of 10, and 99, he's around 109 and still can talk and all that. Mostly we assume that whoever sold it would have been dead, or whoever will be in charge of that family or that stew at that time will not be so interested in chasing it. But you never know how greedy some people can be. But I would not advise you to go and preempt it. That 99 years expires, and then you go to them that, please, my lease has expired. So what do we do? No, let them come. That's the first thing I'll
Mm,
tell you. Aside that, the automatic renewal becomes a right. Immediately you put it there. And so when they trigger that clause, it means that the two of you are supposed to sit and talk about it. We have had it in the law that consent should not be unreasonably withheld, which means that you see the property the person has made, put up on the building and on the
on the
land
land.
and all that. And because of greed, you just want to sack the person because 99 years is an exorbitant price so that the person runs away. That is why you would have lawyers around that you should talk to. That aside, you see, that is why when I was starting, I defined what land is in Ghana. It includes buildings on it. Because the Ashantis say that Edainya Adaka, people would have folded the Adaka into their bags. Wherever you get to, you release them, you just arrange them, you sleep. In the morning, you just fold it into your bag and you go. So that's why it is called immovable property. It means it cannot be moved. So if you have a building on that particular portion of land, it forms part of the land. And so if the person is claiming it, he will claim it with the land and with with
Mm,
with with the property. Do you see? So it's very important that anytime you you are looking at an agreement like that, you should look out for that automatic renewal clause. Because
yeah.
if you want to stretch it for the person to take his land so that you take your building, and he says that, okay, carry your building, where are you going to carry it to? Because the land is his and the building is yours.
Mm,
I mean, that is the law. Where are you going to carry it to? Because buildings are not boxes that you put in your bag. Do you see?
yeah.
Yeah.
Okay. All right. So we can move on.
Yes. So now we are done with interest in land. Let's look at the types of land we have. We are supposed to have 5 types of land. in Ghana, but one does not exist. I just put it there so that you get to understand. The first one is what we call stool or skin lands. Those are the lands that belong to stools, skins, like I explained. And proper person to see when you are buying such lands is that if it is a skin, you have to go and see the occupant of that skin. If it is a stool, you're supposed to go and see the occupant of that stool. So if that occupant is called a chief, you have to go and see the chief. There are some villages or some communities that the occupants of the stools there are queen mothers. So you have to see the queen mother. But if there's a chief, you don't go and see the queen mother because the lands are not for them. We say the occupant of the stool. And those people are always supposed to act with the consent and concurrence of their principal elders. So they are supposed to act with them. If they are selling a land to you, you should ask, who is the occupant? Go and see him. When he is negotiating with you or when he's giving any document, you plead with him that you want to see some of his elders with him for the of witness. For the purposes of witness, the person should be there or those people should be there. So those lands are called stool and skin lands. The second type is what we call family and clan lands. So those are lands that belong to families. Most of the lands in Accra belong to families and stools. Yes. So those ones are controlled by the families or the clans. When you go to the north, there's a group. I don't want to call them clans, but there's a group called there's a group that is headed by people called Tindanes. The Tindana in the north becomes the proper person to see. When you go to the southern part and it's a family land, you have to see the Ebusiapeni of that land or just the family head of the land. I don't know if Accra, the some of them they call them I've forgotten the name.
The
They have
manche or the money.
Manche will be the occupant of the stool, but the family head.
Um,
So you see something with family and something whim and all those things. It gives you an indication where that land is coming from. If you don't really know whether it is a family or it is a stool. Then the third one is what we call public lands. So there are some lands that the government got from colonial times. They have been there. There are some of them that the government has compulsorily acquired from the stools. Just like the portion that is being used to construct the cathedral now. It was compulsorily acquired from the Osu people. That is also a public land. And there are some lands that are called vested lands. The lands still belong to the stools. But some time ago, some stools were just dissipating the land like that. They were just selling. So government said that all those lands are vested. They've given them to the president to take care of for the stools. And so anytime a stool, occupant of a stool wanted to sell that land, that person had to go to the lands commission for consent, for a written consent, a letter that we have given you permission to sell. And then they will add it to whatever they are giving to you before the land becomes yours. But now vesting is no more. It means that government is not doing vesting anymore. Now all the lands that belong to stools have been vested or have been given to the occupants of the stool in trust for their descendants. But vested, those that were vested some years ago still form part of the type called public lands. The fourth one is what we call farmlands. In Ghana, we have some portions that are used for farming alone. So they are farmlands. One day we'll just take a time and go through the law relating to farmlands because it's very, broad. And the fifth one is what in Latin we call terra nullius. It means an unoccupied land, which means land that does not belong to anyone. In Ghana, every land has an owner. If you want to know the owner of a land, just don't tell anyone. Go there and start building, and you see which people will come there. Yes. So those are the types of lands we have. If we still have some time, I can go ahead and talk about some 6 restrictions we should have in mind as far as the acquisition of land is concerned.
Yes, we can do that. You can go ahead.
Can you hear me?
Yes, I can hear you. Can you hear me?
Yes.
Okay, I was saying that you can go ahead. Maybe you can just touch on them and then we'll move to the next.
Okay. Right. Great. So there are some restrictions in the law that you should know so that when you are trying to acquire land, you be careful. The first one is that when you acquire land, the fact that we are saying that land means the surface of the soil, the subsoil, and then the airspace, does not mean that minerals, gold, diamond, bauxite, oil, found under that particular soil in their natural state belong to you, because Article 257 of the Constitution says that every mineral that is in its natural state belongs to the state. That is why galamsey is illegal. You can't just say that you have a cocoa farm, you have some land behind your house, and you feel there's gold there and you start digging because the gold is not for you. It does not include those golden nuggets that have been put in pots by your great grandfathers and hidden under the soil. That one is not in its natural state. It means someone put it there. So that is not in a natural state. By you digging or drilling to extract those minerals, those ones are in their natural state, and you need permission from the government because it's for government. So that's the first one. The second one is that anytime you are trying to acquire a public land, just like I've explained, or a stool land, one way or the other, you need consent from Lands Commission. And it's not a verbal consent, it is a written consent. So you see that a stool will be selling land to you, and then they will say that, oh, you need a letter B from Lands Commission. That's what they are talking about. It is not for you to go and get that letter. It is for the stool to write to Lands Commission that we are selling this land, or we are giving this person this so and so number of years as a lease. Please give us permission to give it to the person. And the Lands Commission will write back that we've given you the permission to give so and so to the person. They will attach that particular document, that particular letter that was given by, or that was written by Lands Commission, to your lease agreement, and that's how you will be able to register it. So if it is a
So
public land,
in
you should
this
always
case,
have it in head.
okay, in this case, how will you know that this specific land requires that you get permission before you can buy it or even sell?
Your line was breaking, so I couldn't really hear you.
Okay, I was saying that in this case, how will you know that this so and so land located here needs or requires that you get consent from
Uh-huh.
Lands Commission?
So it is part of your due diligence, which we'll get to.
Okay.
Because you don't just buy land because you think it is so leveled or it is very close to the roadside, or it is very close to some river and you can enjoy. You do your due diligence, do your searches to know who owns it, how the person got to own it, and all those things. When you do the searches, it will come out. It will come out for you to know that this thing I am trying to acquire is for the government, and so I need this consent. Or this so and so land is a vested land, and so I need consent from the lands commission, so that you tell whoever is selling to you. Mostly those who are even selling don't know. So you tell them that I've done my search, I've done my due diligence, and I know that so and so are supposed to be done. Can you start it? If the person is quite reasonable, the person may ask you to help if the person doesn't know. And if the person knows, he can say that, oh, give me some time, I'll cost my lawyers to do that for me. And then you acquire a very good title. It's very important. So if I may continue, the third restriction has to do with foreigners. We are not discouraging foreigners from coming to Ghana. However, we don't want to sell our lands to foreigners, just like it happened in Zimbabwe. And some South Africans are complaining. And so in our constitution and in the new act, no foreigner is allowed to have a freehold in Ghana. So you can't be a foreigner. When I say a foreigner, I mean someone who is not a Ghanaian. You can't be a foreigner and come to Ghana and buy land. You don't buy. What you can get is a lease. And even the lease, the law restricts you to a maximum of 50 years at a go. 50 years at a go. And so there's this trick that some lawyers are teaching. Of course, it's not illegal. It's just a way of maneuvering around the law to help your clients, and it's allowed. Where foreigners come, they know that 50 years is a maximum. He will get 50 years in one document. And like I said, after the 50 years, it goes back to the owner and it's called reversion. And so they will execute another document. They will sign another document buying the reversion for 49 years. So the 49 years will start from the date the 50 years will end. So when you say that you are a foreigner, you're not supposed to get 99 years, he will tell you that the law says 50 years at any one time. So when he brings you the first one, you know that at one time he got 50. He has not fallen foul of. You got 49. That's less than 50. Even though in reality it is 99 years, technically it is not. It is 50 and 49. They are not the same. Yes.
Okay.
The next restriction you should have in your head is that if you acquire any freehold interest like that, it will not be converted into a leasehold. It is void as a foreigner. To the maximum, you go with the 50 years. Now, when you check section 22 of the New Land Act, you will see that some parameters within which farming rights or farmlands are supposed to be exploited. I'm going to cultivate economic trees. When I say economic trees, I'm talking about these cash crops, like
Or
cocoa,
even timber.
yes, timber, coffee, this one, cashew, and all those ones. Now, there are number of years you can have such lands for. Because if some time ago I was selling someone in Wenchi that I am predicting that in the next 10 years there will be famine in the Bono region, because most of the places where we get food from, they are converting their farms into cashew farms. These are cash crops, and they take a long time to get out of the system. So if you plant those things on the soil, I think I need water. I'm sorry.
No problem.
If you plant those things on the soil, it will mean so there are some restrictions. One day we'll go into them. And the last
Okay.
one is that now you can't sell or buy land on the basis of place of origin, gender. There were some communities that when a woman wanted her husband to front it for her, so now section 11 of the land restrictions that I would think we should discuss. If we still have time, I still have some things to teach anyway.
We have about 15 minutes.
3 minutes.
15 minutes.
Then I would want to look at matrimonial and corporate properties. I've even mentioned the corporate side. Corporate property, we are talking about a company owning a human being. And that company is different from you, the human being who owns it. So immediately the company becomes a company. You have two human beings, you, the owner, and the company. So it means the company can in itself own property, including land. What you should have in mind is that if and that company doesn't use its seal, that is the stamp of that particular company, to stamp on that document, it is not valid. So this is an advice to those of you who have been buying lands from the real estate companies, and then they give you the indenture or they give you the lease agreement. The MD has signed. There's no stamp, and you just take it. You are just holding a paper. You should make sure that the company puts its seal on it, because in law, the seal of the company is the authority of the company. Because anyone can sign, signature, but the seal belongs to the company, and immediately it is put there. It is conclusive that it is the act of the company. The company did it. So you should always have that in mind. Like I said, companies are human beings. And so we have companies that are Ghanaian and companies that are foreign. If you want your company to acquire a lease of 99 years at a go, it means that the shareholders or the shareholders and foreigners owning at most 40%. So if those who hold the shares, 50% of them are foreigners, it means that your company is a foreign company. The maximum you can get is 50 years. But if the company has foreigners to a maximum of 35, 39, 40, it means that your company is Ghanaian, and so that company can acquire 99 years. So that's one of the ways foreigners are getting leases in Ghana. They incorporate the company here, give a bigger portion to Ghanaian partners here. So the company belongs to, say, 4 or 5 people, but 3 of them are Ghanaians who are holding a total of, say, 70% of the shares. And then they acquire the property in the name of the company, and then they are able to register 99 years. So that's corporate property. Let me just take 2 minutes to go through matrimonial property. I know a lot of people will jump at this, so I won't go into detail. In Ghana now, if you are married and during the marriage you are buying land, you should expressly state in that particular document, the lease or the indenture, that you intend to have the land alone as you the man or as you the woman. If you don't state that and you have your name alone in it without that express provision, the law takes it that the property you have acquired belongs to the two of you. And you, the one who has your name in that particular document, you are a trustee. You are holding it in trust for the two of you. It's not for you alone. And so you have to be careful. And where you acquire such property during the marriage and you want to sell it, or you want to lease it, or you want to use it for a loan like collateral, mortgage, and all these things, you are supposed to seek the consent of the other spouse. So if you're a woman and you bought that property during the marriage and it's for the two of you, whether you have written your name in it, the two of you, you have your name in the document or not, you are supposed to tell your husband that I want to use this one for a loan. I want to sell this. When he says yes, then you can sell or you can use it. But it does not mean that you, the husband, can say that chin chin chin, I will not allow you, because the law says that it should not be unreasonably withheld. It's the same way for the men. You say that my name is on it, and so I don't have to tell my wife everything. You have to. Otherwise, if she goes to court that she didn't give consent, whoever got it will be in trouble. They will ask you to bring the land back. Go and take your money from the person who sold it to you. And so I think we will end here today because you gave me 2 minutes. I've even taken 4 minutes. I am sorry.
I
That
actually said 15 minutes, but I
oh
think you didn't hear. So we have
I,
about 5 minutes now.
okay, great. Then let me talk about the last bit,
Okay.
which is the proper procedures. This we will take a good session for it, but I'm just going to go through it quickly. If you are going to buy land, there are 3 things you are supposed to look out for. The first thing is that what type of land or what type of interest am I going to get? 2, you do what we call due diligence. 3, you have to be very careful of documentation. Some of you like, oh, I know him. Oh, my mother knows him. Oh, he's my family friend. You like those things. And when it comes back to bite you, that is when you say that I trusted you. I give my trust and you broke it. I always say that I trust documents more than human beings because documents, they talk once. That is when they are being signed. But human beings, until they die, they always talk. As we are talking now, if we delete this video from YouTube, you can ask me, I will deny that today I met you. Do you see?
Yeah.
So if you are looking at the type of land, you should ask, is it a public land? If yes, I've told you what you are supposed to do. Lands Commission will come in there. So you have to be careful how what procedures you are supposed to take. If it is a stool land, you know that I'm supposed to go and see the occupant of the stool and his principal elders. You know what process to follow. If it is a family land, you know that the head of family, I don't want him to act alone. I have to get some of the principal members. You know what procedure to follow. If it is a usufruct, and you know that you are not an indigent of that society, the community, or you are not a family member, you know what to do. That whoever is given to me has to go for consent from the allodial title holder, and all those things. The procedure will be different. If it's a lease, you are asking yourself, whoever is giving me this lease, what kind of interest does he have? If the person giving me a lease has a lease, is he giving me a sub-lease or he's giving me an assignment? The two are not the same. So the processes will not be the same. You ask those questions. When it comes to due diligence, Someone will do a quick search for you. And then there's formal searches. How you do it? You do consolidated search at the Lands Commission. You do searches at the court. Someone will say, this guy obey book long go. That is how I'm trained. I'm supposed to follow due process so that you acquire a clean title. Some people will do searches at the Lands Commission. Everything is clean. He buys it. And then 2 years later, he realizes that that matter has been in court since. And after you, the new one came, someone has gone back to the court to revive the case. Had you gone to search at the court, you would have known. Collateral. Some people have used their land to take money, and they never tell people who are coming to buy that they've used it for money. You finish buying, that's when you say, "Wait, this thing had a security on it." And to mean that until the person pays it, that particular land belongs to whoever gave the loan. Those things are also part. You site plan.
So there's a question.
Yeah.
Looking at the formal searches, you said for the consolidated search, you should go and do it at Lands Commission. For the
Yes.
court search, where do you go? And then for the collateral registry, where do you also go to make sure that you can search through thoroughly?
So the search, the court searches, it is important to, depending on the size of the land, you may start from the district court or the circuit court or the high court. But I always advise people that the district court and then the circuit court, they are not courts of record. It means that they are not obliged to record whatever goes on in the court for you to go apply for and get. That's what we call law report. Those cases are not normally reported. But the high court is a court of record. And so anytime you apply for a search, you do a search at the high court, you always get. And that is why you need a lawyer. I'm not doing an advert for myself, but I'm telling you the proper procedures. Yes. You need a lawyer. He will know how to conduct the search. Sometimes you never know who has been sued, but you may get the name of the family or the stool that is trying to sell. And then you use that name to ask the court that between so and so years, can you search your records to see if there has been any case about. The lawyer will do his diligence to make sure that there is not. Their website is the most accessible I've seen. You can conduct a search there at a very, very small amount. Very, 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 very small amount. Oh, can you check to see if so and so land has been used for as collateral? Because in Ghana, if you use immovable property, land, as collateral for a loan, the person can only enforce that security if it is registered. And the collateral registry is the one that registers the security. And so if it is not there, it is assumed that even if there's any security, it's not enforceable. You can go ahead. So that's what I meant by the court and then the collateral registry. Yes. So you also be looking at documents. Some of you say, "Oh, also on first site plan, no, mame." That's a red flag. He has to give you a site plan. You also do your own site plan to do your searches, but he has to give you a site plan so that you do your searches. You need site plan. You need what we call contract for sale. If he is giving you a lease, contract for lease. There are some portions in Ghana that you don't have to register the land. They are not registrable areas. The eastern region, some part of you, then you may proceed to then what was called town planning. There's an office they used to call town planning. Now their name has changed. Town planning, you go there. Some places you have to go to lands commission, and then you register the deed. When I say the deed, I mean the indenture that has been given to you. You go and register it, but you don't get certificate of title. That is also important. When you take the indenture, you check the back and you see oath of proof and certificate of proof. Some of you don't want to even look at it. That, oh, it's not part of the agreement. It is important. That is why it's put there. Go to the court, high court, you see a registrar of lands there. He will endorse those ones and put the stamps there. You have to get it. If you don't want to work there, you should go to the lands commission. Let them stamp it for you. And where it is in Accra, try and register it and be free. Even if you lodge it for them to go, I mean, the first registration, it goes through the process to get to what we call SMD. That is a survey and mapping division. It means that anyone who conducts a search, now we do consolidated search, which means all the three departments under Lands Commission will give you results. Immediately, it passes through that particular stage. Anyone who conducts a search will get it. It will pop up that someone has started registration. It's called plotting, that it has been plotted. The person, if he is not a mansutrini, I mean a litigant, the person will know that someone's on the land. I have to contact this person. I have to be careful. So that is the end of my presentation. I welcome further questions if there are.
Okay, so thank you very much. It has been a very insightful session. If anyone has any questions, you can just drop it in the comment section. But before now, some people sent me their questions. We'll take just about 3 because our time is fast spent. Then our next session would address more of it. So the first question is that, is it necessary? I think this was answered, but is it necessary to indicate in the indenture, if you are buying a family land, the name of the person selling and then the name of the family you are buying it from?
Yes. That is why I said that if you are buying it from a family or you are buying it from a stool, if it's a stool, it is the occupant of the stool that is supposed to give you. If it is a family, it is the head of family. But they are not selling it in their own names. They are selling it because they are in such positions. And so the indenture is going to, if it's a family land, it's going to be between the family and you, the one who is buying. So if that person writes his name there, maybe one day he dies, you produce that document, the family will come and tell you that it is a family land and the person sold it to you as if it is his own land, and so they are taking their land. I can assure you that 80% of these things are lost in court. Yes.
Okay.
You have to be careful.
So this other question, I think it has to do with the interest in land. So what if you're given your 99 years and I think you answered it. It has to do with you ensuring that the automatic renewal is included.
Yes.
Because if it's not, I mean, it also has a channel that it goes through.
Yeah.
The next question is that, please, how do you go about a freehold land with no registration? I don't understand the question. I don't know if you do. How do you go about a freehold land with no registration?
So if there's no registration, it does not mean that it doesn't belong to anyone. So whoever you are getting it from, the two of you should be able to sign the indenture. You're supposed to get a site plan prepared. I always advise that you get the barcoded site plan. That is if it is in Accra.
Okay.
Then you can lodge it.
All right.
Yes.
Is it compulsory to indicate the purpose you are buying the land for in the indenture?
It is not compulsory, But sometimes, for the sake of um, future matters or issues, some lands are not meant for some specific purposes. So there are some lands that, where they are located, if they allow you to put a factory there, some years to come, that place will be a residential area and your factory will worry people. And so
Mm,
they want to put in there that it is supposed to be for residential purposes. And you know that the spatial and planning, um um office
department.
I was talking about, we all have such demarcations. The towns have been planned such that there are places that you can only live, like residential area. There are some
Mm,
places where you see Tema, where the factories are.
yeah.
People don't necessarily live there. Aside a few people who have been very recalcitrant and they want to live there and they want to endure the fumes and all that there. Yes. But if the place is demarcated for residents, you will not be allowed to farm there. That
Mm,
is why mostly it is stated in there. However, if the grantor, I mean the one granting it, feels that it is meant for anything, of course, they will not state anything there. But you should always,
okay.
special and town planning unit or whatever will catch up with you, depending on what you are
Okay.
doing there.
Hmm. So the last two questions, it says that um, if the family, if you buy a family land or a stool land and you want to sublease or assign, must you inform them that you are subleasing or you are assigning your interest?
Yes. When you get a lease, people don't even read the indenture. It is one of the clauses we put in there that when you are assigning or you are subleasing, it should be with the consent of your lessor. The reason is that at the end of your lease, that particular land will go back to them. So if they don't take care, if they are not in the known that you are granting so so and so to this person and you go overboard, it's going to go against them. Secondly, they know that it is likely to come back to them and they are granting it for to you. So if they are not in the known and you give it to someone to produce or manufacture guns there, it is still going to have a dent on their name. So it is always in the agreement that do not sublease or do not assign without the prior consent of the lessor.
Okay.
Yes.
So the last question will actually lead us into our next session, but I just want you to touch on it for our listeners' sake, anyone who might be going through such an issue. And it has to
Mm,
be with the issue of this multiple sales and litigated lands, and
yeah.
you can't trust who you are buying this land from. As an individual who probably is starting life, or maybe at any point in life, they want to buy a land in Ghana, they've identified these people, they've done their due diligence, and then in the middle of it, you see, it they realize that 3 or 4 people have bought the land, and it's a current issue
You,
that is really going. Okay, am I clear now? Am I clear now?
yes, yes. I can hear you now.
Great. So there are lands with multiple sale transactions from the same family or the same school. They've sold it to multiple people, and you happen to be a victim. And these court issues take time. You see, now it's not really about what the person should have prevented because it has happened. So definitely the person will learn from it. But how do you navigate your way through to come out of it? Either you get your refund or you get your land, or how can you be sure that the law can protect you when if you find yourself in this situation?
Okay, a great question. Now the new Land Act, one of the most beautiful provisions in there is what you're talking about, where there'll be multiple sales, or where people are preventing others from enjoying their land. Now, it has been made an offense that can be reported to the police station for the police to cause an arrest. And whoever does such multiple sales is likely to go to jail or be fined hefty amounts. Yes. Another way of dealing with it is that you have to go to court. And going to court, you may ask for a refund of the price you paid with interest and cost, or you may say that you still want the land, and so what we call specific performance, that you have paid or you've performed your part of the contract, and so the court should force that person to give you a land.
Mhm.
So those are the two avenues that are available to you. I will not encourage langas.
Mhm. All right. I was actually going to talk about lanyards, but we'll add that to our next session. So thank you very much, Prince. This session has been very enlightening. I hope everyone that watched or will watch later will actually get some tips from this. If you need the contact of our lawyer, you can reach me on my number. I'll leave it in the description box, or you can check my website. I'll forward all his details. You can reach him if you have any legal issue or concern. He can consult for you. He can help you with any court issue that you're facing. So thank you very much. It's been an honor to have you here. We hope to see you again in our next session. And we hope that our viewers and listeners also learned a lot from this. So we're going to end today's session here. And the subsequent sessions will be shared across all platforms for you to prepare for. So have a blessed Tuesday evening. And until we meet again, take care, everyone. Thank you. Once again, my name is Judy, and I'm a property consultant in Accra, Ghana. See you guys.
Okay, all right.